This video is not legal advice. It is for educational purposes only. It does not create an attorney-client relationship. Always consult a qualified attorney for advice specific to your situation. Having broadly surveyed litigation, the California institutions that support and stage litigation must now be examined. Those various institutions are collectively classified under the term judiciary. The term judiciary refers to one of the three branches of our Republican form of government, the other two being the legislative and the executive branches. To be precise, judiciary denotes the court systems of the federal government and the state governments. These two parallel court systems, federal courts and state courts, both operate in California. The California federal courts sit within the Ninth Circuit, one of the 13 circuits that comprise the federal appellate court system. That system is, in turn, subject to review by the 9 justices of the highest court in the nation, the United States Supreme Court. The 13 circuits consist of 12 regional circuits, 1st through 11th, plus the District of Columbia Circuit, and one nationwide federal circuit that handles specialized appeals involving patents, international trade, and certain claims against the government. Of the 13, the Ninth Circuit is the largest. All circuit courts typically sit in 3 justice panels that do not retry facts, but adjudicate legal issues on appeal. As an aside, the term circuit for appellate courts harkens back to the days when justices would periodically travel, literally riding circuit on horseback or by carriage, to adjudicate appeals in various locations. Subject to review by the California Federal Circuit Courts are the United States District Courts, which function as the federal trial courts. United States District Court judges are appointed for life by the President of the United States and confirmed by the United States Senate. California's federal district courts handle both civil and criminal cases and are organized into 4 judicial districts. The Northern District, headquartered in San Francisco and covering the Bay Area and coastal counties up to the Oregon border. The Eastern District, headquartered in Sacramento and covering the Central Valley and Sierra Nevada region. The Central District, the most populous, headquartered in Los Angeles and covering 7 counties including Orange and Riverside. And the Southern District, headquartered in San Diego and covering San Diego and Imperial counties. Operating alongside these federal courts is the judicial branch of California state government, consisting of the state courts and their ancillary institutions. California state courts are organized in a hierarchical structure of trial courts and appellate courts that mirrors the federal system. The trial courts and appellate courts are, in turn, subject to review by the state's highest court, the California Supreme Court. The California Supreme Court serves as the court of last resort for disputes involving questions of state law. All hierarchically lower state courts in California are bound by its decisions. The California Supreme Court operated out of San Francisco until 1854, when it was ordered relocated to the yet-to-be-determined state capital. Although the state capital was ultimately seated in Sacramento, the Supreme Court returned to San Francisco in the early 1870s. In 1874, the state legislature directed the court to hear cases for 2 months each year in San Francisco and 2 months in Sacramento. In 1878, the legislature added Los Angeles as a third forum where the court would hear arguments for 2 months per year. The California Supreme Court reviews lower court decisions that are likely to alter existing law or to resolve disagreements among the courts of appeal. It also reviews all state death penalty cases and disciplinary proceedings involving California judges or lawyers. Like federal appellate courts, the California Supreme Court is composed of judicial officers called justices. There are 7 justices, 1 Chief Justice, and 6 Associate Justices. Although all 7 justices hear arguments en banc, in cases granted review, only 4 must agree for a lower court decision to be affirmed, modified, or reversed. California Supreme Court justices must be lawyers with at least 10 years of experience as attorneys or judges. Under a system adopted in 1934, Supreme Court and appellate justices are initially appointed by the governor, subject to confirmation by an agency known as the Commission on Judicial Appointments, and then appear before the voters at the next general election. They serve 12-year terms and must stand for retention by the voters at the end of each term. The court holds regular sessions in San Francisco, Sacramento, and Los Angeles, and special sessions in other California cities as needed. Below the California Supreme Court in the state judiciary's hierarchy are the intermediate appellate courts. California's appellate courts were created by a constitutional amendment adopted on November 8, 1904. The amendment was prompted by the Supreme Court's severe 1882 case backlog, which had resulted in decisions taking an average of 2 years. In 1885, the legislature authorized the Supreme Court to appoint 3 commissioners to help clear the backlog. 2 more were added in 1889. All commissioners were eliminated in 1904 with the creation of the appellate courts, which were not officially designated the Court of Appeal until November 1966. There are 6 California Courts of Appeal, which divide the state's 58 counties among 6 appellate judicial districts, 3 of which contain divisions. The first district is in San Francisco, the second in Los Angeles, the third in Sacramento, the fourth, Division 1, in San Diego, the fifth in Fresno, and the sixth in San Jose. The entire appellate court system consists of 105 judicial officers, also referred to as justices. As noted, these justices are appointed by the governor and confirmed by the Commission on Judicial Appointments. To be eligible for appointment, an individual must have been an attorney or a California judge for 10 years immediately preceding appointment. After initial confirmation, justices serve the remainder of their predecessor's term and then stand for election to a 12-year term at the next general election. Ordinarily, a panel of 3 justices hears and decides appeals. 2 justices must agree to pronounce judgment. The justices do not retry cases. They hear no witnesses and impanel no juries. They do not second-guess the trial judge or jury on matters of fact, although they may review whether the evidence was sufficient to support a legal judgment. Their primary role is to review the law applied in the trial court, relying on the trial transcripts, party briefs, and oral arguments. When the justices decide an appeal, they issue a written opinion explaining the reasons for their decision. If an appellate opinion alters, modifies, or establishes new law, it is published in the multi-volume California Appellate Reports. While all appellate opinions are publicly recorded documents, fewer than 10% are published in the California Appellate Reports. Appellate opinions affirm or correct the decisions of California's trial courts, which are all designated superior courts. Prior to 1994, California's trial courts had 3 designations: superior courts, municipal courts, and justice courts. Justice courts were merged into municipal courts by a 1994 constitutional amendment. A further constitutional amendment in 1998 authorized the unification of municipal courts into superior courts. By 2001, all municipal courts had been unified with their respective county superior courts. With the elimination of the traditional lower courts, superior courts now handle all criminal actions, civil actions, special proceedings, and appeals from small claims, traffic infractions, and misdemeanor cases. Civil actions once handled exclusively by superior courts are now termed unlimited civil actions, while those formerly handled by municipal courts are classified as limited civil actions. Superior courts resolve these matters through judges and juries, who hear testimony, consider evidence, and apply law to facts. Each superior court also maintains an appellate division, consisting of 3 or 4 judges designated by the Chief Justice, to hear appeals from traffic and limited jurisdiction cases. All superior court judges are responsible for the day-to-day operations of the state trial courts. They must remain impartial toward all litigants. Accordingly, judges and court staff may not provide litigants with legal direction or assistance in prosecuting their claims. Judges also adopt local court rules governing case management, leadership selection, and other matters. To qualify for the office, Superior Court judges must have been members of the public corporation known as the California State Bar for at least 10 years. They serve 6-year terms. Many begin their service through gubernatorial appointment when an incumbent retires, dies, or resigns. Appointed judges who wish to continue must run for election at the next general election. If no eligible attorney files to oppose them, the judge is reelected without appearing on the ballot. Judges are not the only judicial officers in the trial courts. Many routine matters are handled by court-employed attorneys known as commissioners, who commonly preside in misdemeanor, juvenile, restraining order, eviction, family law, small claims, and traffic cases. Commissioners serve at the pleasure of the court and are generally paid less than judges. Because commissioners are not judges, litigants in certain proceedings, such as evictions, cannot be required to submit their disputes to a commissioner instead of a judge. Every 2 years, the judges of each large county elect a presiding judge responsible for case assignments, managing the trial court budget, and establishing court policies and procedures. The presiding judge may appoint supervising judges to oversee major divisions such as civil, criminal, family law, probate, and juvenile matters. Assisting the presiding judge are court executive officers, hired according to procedures adopted by each trial court. These officers manage the non-judicial administrative and operational functions of the court, including human resources, budgeting, accounting, and case flow management. Today, there are 58 superior courts in California, one for each county. Although a county may have multiple court buildings, there is, strictly speaking, only one superior court per county. Historically, the state and counties shared responsibility for court operations, with counties funding trial courts, constructing and maintaining facilities, and employing most court staff. By the 1990s, some trial courts faced potential closure due to county fiscal constraints. To reduce the trial court's complete dependence on county budgets and to promote more uniform performance standards, the legislature enacted the Lockyer-Eisenberg Trial Court Funding Act of 1997. The act made the state primarily responsible for funding trial courts while counties retained responsibility for personnel and facilities. It gave the legislature authority to appropriate trial court funds, empowered the Judicial Council to allocate those funds to individual courts, and allowed courts to carry over unexpended funds to the following fiscal year. The Judicial Council is the agency of the California Judiciary that fulfills many of the administrative and fiscal responsibilities that other states would assign to their Supreme Courts. It was created by a 1926 amendment to Article 6 of the California Constitution. As restructured by a 1966 constitutional amendment, the Judicial Council consists of 21 voting members and 6 advisory members. The Chief Justice, who serves as chair, 14 appointed judges, 4 attorneys appointed by the State Bar's Board of Governors, 1 state legislator, and 6 advisory members. Following the 1997 funding realignment, the Judicial Council assumed responsibility for allocating state funds to the trial courts. In general, the Judicial Council studies court operations, adopts statewide rules and policies after receiving comment from lower courts, and recommends improvements to the governor and legislature. It surveys statewide court operations, drafts rules for court administration, practice, and procedure, and publishes 2 annual reports: the Judicial Council Annual Report and the Court Statistics Report. The Judicial Council was formerly assisted in financial, human resource, and legal matters by staff known as the Administrative Office of the Courts, or AOC. The AOC was not a separate legal entity, but simply the formal name for the Judicial Council's own staff. Because of widespread public confusion about whether the AOC was an independent agency with policy-making authority, the Judicial Council retired the AOC name in 2014 to reduce confusion, improve transparency, and present the Judicial Council as a single cohesive entity. While the Judicial Council governs the California Judiciary's administration and policies, other constitutional branch agencies address judicial appointments and judicial performance. One such agency is the Commission on Judicial Appointments, whose function is to review and confirm or reject gubernatorial appointments to the state's appellate courts. The Commission on Judicial Appointments has no role in Superior Court appointments, which are made directly by the governor and confirmed through other processes. The Commission consists of the Chief Justice, the California Attorney General, and the senior presiding justice of the relevant appellate district. Another is the Commission on Judicial Performance, established by a November 1960 voter referendum and strengthened by subsequent amendments in 1966, 1976, 1988, 1994, and 1998. This independent state agency investigates complaints against and disciplines California judicial officers. It is composed of 3 judges, 2 lawyers, and 6 citizens. The Commission also has authority to discipline former judges and commissioners. Discipline of attorneys in general is delegated by the Judiciary to a public corporation known as the California State Bar. Created by the legislature in 1927 to function as an arm of the California Supreme Court, the State Bar is a public corporation in which all practicing California attorneys must maintain active membership. Lawyers gain admission by passing the California Bar examination, paying annual membership fees, and meeting other requirements. The State Bar then certifies qualified applicants to the Supreme Court. The State Bar also enforces professional rules of conduct through disciplinary proceedings and requires all members to complete 25 hours of continuing legal education every 3 years. In addition, it awards certificates of specialization in at least 8 areas, including appellate practice, criminal law, family law, probate and estates law, workers' compensation, taxation, bankruptcy, and immigration and nationality law. In sum, litigation is supported and staged by functions of the various institutions that together constitute the California federal and state judiciaries. These functions can be distilled into 3 core juridical tasks: to provide a forum for determining whether a person charged with a public offense or crime is guilty or innocent, to afford everyone reasonable access to an official forum in which legal disputes can be resolved peaceably, efficiently, and fairly, and to interpret laws and declare the rights guaranteed to persons by the constitutions of California and the United States. Final reminder: the contents of this video are for educational and informational purposes only. They do not constitute legal advice and are not a substitute for personalized guidance from a licensed attorney, familiar with your specific facts and circumstances. No attorney-client relationship is formed by watching, liking, commenting, subscribing, or communicating through this channel. Laws change over time and vary by jurisdiction. Do not act or refrain from acting based on anything in this video. Seek advice from a qualified professional in your jurisdiction. The creator disclaims any liability for loss or damage claimed to result from reliance on this material.